Welcome to the Immigration Lawyers Podcast. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult an immigration attorney for specific information related to your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. Hi everyone, welcome to this month's episode of the Immigration Lawyers Podcast. This month I'm going to do things a little differently. When I started the program, I was really interested in doing interviews and talking to people and learning about how other people are in their practice and how they manage being an immigration attorney. I still want to do that, but more recently I got interested in doing deep analysis of case law, really even more focusing and making the podcast more directed toward people who specifically practice immigration law and getting into the nuts and bolts of the law and the practice. And I'm still going to do that, and I'm getting a kick out of it. For this month, I had planned to do a deep analysis of the 237A1H waiver, which is for people who are facing removability based on fraud or misrepresentation, but who could get that waived and keep their green card. It's a really neat waiver that fortunately is not well known, and when I got into analyzing it and studying the case law on this, I saw so many examples of removal cases where the attorney unfortunately didn't use this option that was there, and the client was found removable and eventually removed from the country. So I thought it was something that's very important that every immigration attorney should know. Even those that do transactional law, if you're doing naturalization, it's good to know that this waiver exists in case something pops up in NATS, or someone who did their own NATS a lot of times and then comes to you and says they were denied and now they're going to removal proceedings. It's a good thing to know and to help relieve worries that your clients may have. It's definitely a good option. However, when I started to do the analysis, I want to do it so deep and all-consuming that I downloaded and read every single case that's ever mentioned this case law, 237, before it was called 241, for the last 60 years. And it was almost 50 to 80 cases. And my analysis is almost going to be a book. So I decided it's probably better I submit this for a law review or something. I've already spent almost 20 or 30 hours working on it. It's going to be another 20 or 30 more probably. And I'll eventually do a synopsis, a short version in the podcast and let everyone hear it. But for now, I thought it's too big and detailed for the format that I'm sharing with you right now. So today instead, I'm going to review some important things that have come up, an overview. I'm not going to go into depth about all of them, but that immigration attorneys should know that have happened in the last month or two with regard to our field and case law, statutes and everything, that it just current events that could help you in your practice be more aware of what's going on. Well, the first thing I want to discuss is the AILA conference that happened in Las Vegas in late July, I believe it was. It's been about a month now or so. It was a wonderful conference. Vegas was hot, but the hotel was great, and it was an exciting time to see all of our colleagues everywhere in one place and see the faces to the names that we see on the listservs and on the websites and all the various things we do in the cases. I also learned a lot about other areas of immigration law which I don't practice and which I don't talk about here as much, for example, criminal and removal proceedings. As such, I think it's really important that if you're going to practice immigration law, to try to go to one of these conferences, and if not, download the tapes. I'm a liaison and a committee member for AILA, but I'm not plugging them. They're not aware that I'm saying this, but I would definitely recommend, if you're going to practice the area of law, to participate somehow with these events and the organization itself. It helps to learn a lot and to meet people that could help you get to where you want to go. I can't count how many times people I've met through AILA have helped guide me and give me advice and save me the time of having to do hours and hours of research. And they taught me on-the-ground stuff of exactly how it actually happened as opposed to how we would read it in cases or in books, as y'all know. Moving on to some news in our practice area. I have an article here from Fox News that says Federal Immigration Court Backlog tops 500,000 pending cases. This is just insane, the backlog that's going on right now with immigration courts. I don't do removal proceedings anymore, but when I did, I remember we'd have cases where the judge would put a calendar for 2, almost 3 years sometimes in the future. And it's incredible that this even exists. One weird thing, and I don't really go into politics because I don't agree with any of them. I'm not on one side or the other. I'm against both sides. So it's kind of confusing. The conservative aspect would be to unfund these immigration programs, but that causes there to be less immigration judges, creating backlogs and causing people who are here unlawfully to potentially stay here longer or get administrative closure. So it hurts on that end. On the other side, though, if they add more judges, these cases will be finished sooner, and this sort of a gift for people to be able to stay here pending their case would go away. I remember it was a benefit to the clients to be able to just wait it out here and have to worry about their case coming up for another couple of years, and then something would happen where you'd have to request a continuation that would go another time, and all of a sudden they'd be here for many years just waiting for their case. On the other side of that, clients who were frustrated with that and just wanted to get their case or leave, and they're over it. So it goes both ways. But it's incredible. It's 500,000 cases pending. Is intense. And when you look not just at the federal courts, but also asylum office, which, let me take a look now how much that's pending. The USCIS.gov website is showing cases filed in Los Angeles in 2011 are just now getting their appointments. In other parts of the country, cases filed in 2013 and 14 are seeing interviews. But in LA, where I am, a person waiting years and years for asylum. And that's the primary reason I don't practice asylum law anymore either, because my clients were getting frustrated. I was getting frustrated. Getting a client and signing a contract now for an interview that's going to happen 4 or 5 years in the future sounds crazy. I'm not even sure that the statute of frauds permits that. I can't remember my contract law from law school, but having a client sit there and wait for that, and it's so frustrating. And I see it still today. I have every 10 days or so, I have an asylum applicant that calls me, telling me how bad their attorney is. They haven't had their interview yet. They're waiting so long. What's going on? And I have to explain to them, I don't know what kind of work they did, whether they're a good attorney or bad attorney, but in Los Angeles at least, and in the area that the LA office, asylum office, and Anaheim covers, it's quite reasonable to wait this long, unfortunately. And this backlog is not only for the humanitarian removal proceedings, but when we look at I-526 cases and just general EB-5 cases, which is more of a focus on my firm, every month the delays increase. I don't think there's been a month in the last 6 months where it hasn't increased the processing times, where the I-526 is taking 16 and a half months. Removal of conditions is 20 months now, 20.1. That's incredible. And I really wish this information about these processing times would be more well known publicly in the news agencies, because the critiques I see of the EB-5 program are, just buy citizenship. You just hand over money and buy citizenship. Whereas there's huge problems with the investments not working out, so it's a huge risk on these immigrant investors. The processing times take so long, it's extremely frustrating, where it takes years and years to actually be able to stay in the U.S. So the narrative is that you're just giving out green cards, and it's just not the case. So practitioners should, if they have access to the media or you write articles, definitely highlight this issue, that these processing times are unreasonable, and it's not a gimme that you just get green cards and visas and just stay in the U.S. It's just not the case. One other area which I've seen a slowdown is for visa bulletin F2A category, spouses and children of permanent residents. I think it's since April, these cases have been moving forward in the visa bulletin only 1 week every month. Every time the visa bulletin's out, it moves forward only 1 week. And this month, it didn't move at all for the F2A category. The other ones aren't that much better. The F1 is moving normally. I've seen 8-week jumps, 9-week jumps forward, so that's not bad. But I have couples. I have one couple in particular who are going to get a divorce now. They've been waiting for so long for this to come up. The relationship just got torn apart. And so when we talk about immigration reform, this separation of the F2A category in particular, spouses of permanent residents, children of permanent residents, that has to be sped up. Now, brothers and sisters, parents are immediate relatives, but unmarried sons and daughters or 21, these are people who are independent. They could be on their own and separated. But when you have an F2A category where a spouse has to be in the U.S. and working separate from their spouse abroad, it tears apart relationships. And so when we look at case law, and I saw this when I was studying 237A1H a lot, the purpose of a lot of these statutes is to unify families, and this does the opposite. And especially when you look at the domicile requirement for the affidavit of support, when one spouse has to come back to the U.S. and live here and work to show they're not living abroad, it forces people to be separated for long periods of times, and it destroys family relationships, destroys marriages, and that has to be something to focus on. This is a legitimate way to come in the country in immigration. It's not one of those hot button issues of someone who's a U.S. person marrying a foreigner and bringing their spouse here. That's not a controversial issue. And if we're a country that believes in family, we got to work on making these times go slower. Now, brothers and sisters, 14 years, 15-year wait times, I wish it wasn't like that, but it is what it is. And I'm talking about generally. I'm not looking even at China and Mexico. I'm looking at F4 category of Mexico. It's 1997. It's 20-year wait. That's incredible. I mean, F3 category is since 1994. It's just crazy numbers. But again, if you're married, I'm about to get married. I can't imagine having this kind of distance from a spouse for such an extended period of time, such a long distance relationship. It's very harmful to the people involved. Moving on from that, there was an article by a website called numbersusa.com where it says USCIS confirmed that 2,994 DACA recipients have been approved for adjustment of status. The article calls it permanent amnesty. It's kind of somewhat a negative terminology for it, but it's interesting to show that it's legit the ability of a person who has deferred action for childhood arrivals, DACA, getting advanced parole, leaving the country and returning as a parolee and getting the ability to adjust status and not having that problem of being here unlawfully. That's if their immediate relatives are a U.S. citizen. And it's been working. There's still people who don't believe this or think it's a lie even, but it's legitimate, it's official that this method does work. There's fear that talking about it might cause some upheaval and cause it to be removed through Congress or through the service. Now we approve these, but as the case law goes right now, when you return with advanced parole, you're allowed to be a parolee and adjust status. And from the conference, the AILA conference, people have been getting these advanced paroles. They haven't been too crazy. Getting emergency advanced parole in LA, at least, it's a little bit difficult. You have to show some immediate harm. I mean, the person has to be going back to home country for some extreme reasons. But getting advanced parole regularly through the I-131 hasn't been too difficult if the documentation is good. So that's definitely a route I would recommend people to do. Clients are afraid of the consequences of not being able to return to the country. I'm not too worried about that as long as you do a thorough background check of some sort to make sure they don't have any arrests or warrants or removal proceedings potentially, anything that could cause problems when they're returning into the country. And I've heard a story where a guy had some criminal history and he did this and he was caught at the border, couldn't come back in. But they should have known that. The attorney should discuss it with the client to make sure they clear before doing this large step. But hey, that's the way to go. It's a little bit of a magic step. It's definitely worth trying out. Going to the humanitarian area of immigration law, TPS status was extended for El Salvador for another 18 months. So that's something to keep in mind. I don't usually practice TPS myself. TPS popped up for a client of mine that I was doing a business visa extension for, and because I don't do TPS regularly, I brushed it off, and it wasn't until like 2 or 3 weeks before the deadline where I realized that's an additional option for my client to have. So I filed the last second and had to figure out how TPS works, and it wasn't too complicated. But for those who don't usually practice in this area of law, it's important to know and keep an eye out in case someone from one of your clients from one of these countries has this option. It's definitely something to have in your back pocket. Now onto the more controversial aspect. TPS was extended for Syria as well, and this has been in the news because of all the brouhaha about allowing Syrian immigrants to come into the U.S. So it's something to be conscious of if you have Syrian clients, apply for TPS or do their extension request. Now there has been some changes in case law and statute. An interesting case came down from the Third Circuit in the case of C. Mensen v. Attorney General, I'll give a short synopsis of the case. It's regarding K4 children who come to the U.S. and go over 18 but want to adjust status because their parent has been able to adjust status. There was a weird area of the law where the K4 status visa would let the child come and stay in the U.S. up to 21, but they can only adjust status up to the age of 18 based on their parents. And this issue came up, and the case went up to the Third Circuit, and the Third Circuit's conclusion was that 8 CFR section 245.1I, which discusses this issue, is invalid. So that's something to keep in mind for those of you who have fiancé visa clients who bring their children and their children turn 18. This is some case law that could potentially help you. Another important update to the law that just happened very recently is the expansion of the unlawful presence I-601A waiver, which isn't in effect yet, and we should get an updated form I-601A pretty soon, I think in the end of August, I believe. But essentially, in addition to being able to use this waiver based on the relationship to a U.S. citizen, spouse or parent, they've added the relationship with an LPR spouse or parent. So the number of people who can use this have been increased. Also, there was a cutoff date where only petitions, I believe, who had the embassy processing begun after January 3rd, 2013 were able to use it. Now that cutoff date is gone, and people who had their case before that could use this waiver as well. Also, under the 2016 rule, an individual with a final order of removal, deportation, or exclusion may apply for a provisional waiver if they had filed a Form I-212 and the application had been conditionally approved. Finally, something to be careful of is there used to be a reason to believe standard where if the USCIS officer reviewing the 601A found some reason why this person may be subject to a ground of inadmissibility, they would deny the 601A. However, they're removing that. So now if you're sending the client overseas, be careful. Make sure to review their background before they leave the country, because you don't want that coming up during consular processing at the interview and have them stuck outside the country. Furthermore, on these kind of executive decisions, which the I-601A was, the governor has requested a rehearing of DAPA, D-A-P-A case at the Supreme Court, which was challenged by Texas and several other states for allowing parents of U.S. citizens to be able to have a similar situation as DACA, getting a work permit and getting a deferred action and being permitted to live in the U.S. without fear of removal. Finally, I want to talk about a law school specialty ranking for 2016 that was published by a website called lawstreetmedia.com. This is a little bit of self-advertisement, but I'm happy to see that of the top 10 immigration law programs in the country, Loyola Law School, my law school, and the school I'm an adjunct immigration professor at, was ranked number 7th, right after Yale, right before Cornell. Berkeley was number 9. And number 1 was New York University, 2 was Columbia Law, and 3 was Harvard Law School. So I was very happy to see Loyola being represented, and just happy to see immigration programs in top law schools throughout the country really striving and expanding. It's become a really, really big program, and many of the schools here in Southern California are expanding their clinics and the various types of immigration programs they have. So it's a wonderful way for students to know the intricacies that are involved in our practice. Thank you all so much for listening to this episode. I like the format that I did today because it's really no planning and just talking openly about subjects there is, and it makes it much more easier to pump out more material. But I'm still going to do a lot of the legal analysis, and I'm actually have one case I wanted to talk about today about affidavit supports that I'm going to do a separate podcast on because it's very nuanced and it'd be too time consuming and off topic to put it all here. If you have any questions, please email me. My email is info@jqqlaw.com. The podcast is immigrationlawyerspodcast.com. You can find me on iTunes, YouTube, and other places, I believe. Also, if you're a lawyer, please email me and subscribe to the Immigration Lawyers listserv to communicate about cases from various specific countries and regions in the world. Consular processing is such that may be affecting your cases. You can talk with other practitioners that deal with those same issues. Thanks so much. Have a great one. Bye-bye.